So, this is a recap of what just happened. Just to give you a quick timeline, I got there at 9:10, probably started at 9:15. No jury. Jury came in probably 9:40, 9:45 when they started recording. He asked me if I was recording with a Garmin heart rate monitor on my wrist. I was not. Says he can't record. We're not recording. He bosses me around, tells me what I'm going to do for a minute, tells me one of the three motions, and we'll get into all this, that Murphy filed that I couldn't read since the last hearing 2 weeks ago, and then brought in the jury. This, again, just a quick summary before I bring Gary in here. This is probably the closest I've come to actually being thrown in prison. I was so close to being held in contempt that before the jury showed up, he said that I actually was held in contempt, but not going to jail, that he recorded it that way. And what caused this? I referred to him as my enemy and wanted the court to formally notice that this judge was now formally recognized as my enemy because of his actions. And of course, he didn't like that at all and threatened me with jail for it. So I continued risking jail to clarify what I was talking about, and in the process of doing so, said the word enemy again in reference to him, but not like calling him that or accusing him of that. So that was when he said, "Oh, okay, I'm holding you in contempt," and let it hang a little bit. And I thought, "Oh, okay, I'm going to jail." I'd already told the bailiffs, if he arrests me, I told him twice, I'll just put my hands behind my back. Here you go. And he ended up not. So that's how close I came. Just making a note. This is the most severe it's ever been. They are just 100% steamrolling. They don't care about anything, due process. They're 100% convinced this will never get online and that the appeals court won't care at all. There's an appeals court in downtown St. Louis where this will all go next. And just a quick recap again is 9 o'clock started. Okay, it was over by 11. We had a break at 11, 10-minute break. Came back. Prosecutor had just done voir dire. I then started voir dire. He said I had 45 minutes. I got through like question number 4 or 5. And without getting into specifics, my questions just revealed that a dog attack is part of this case. An allegation of an attack and me defending myself is part of this case in my front yard. And he did not allow me to ask that question. He said that's providing facts, not an evidence. And my sentence actually said, if evidence is found. It didn't say. So anyway, there's so many details that we could go in, so many things we could cover. We're just a million different ways. We're chomping at the bit here to go over it all. It's impossible to do in one big matrix plug download into people's brains, but we're going to give it a shot here, Gary. There's 3 minutes already I'm in, just giving a basic recap.
You recap from like the high level perspective.
Yeah.
But of course, the details are kind of in the weeds of this because, again, there are motions from the opposition that were handed to you and granted before you were done reading them.
Yes, if you look on CaseNet, you can see February 2nd, February 9th, and February 10th or 11th. There's 2 motion in limines and 1 motion to endorse something for additional witnesses.
To be clear, just how CaseNet works.
Yeah.
In this instance, these parts of CaseNet, you have access to see that there's a thing, but you cannot read it itself. Correct. Lawyers have access to that. And people who have a reason to have access, I guess the courts and so forth have access to that.
Bar members are allowed to get an account. Yeah. I am not.
You're not. So the first opportunity of actually seeing this thing that was quote unquote filed and supposedly even had a certificate of electronic service that they said was delivered to you, that it was served to you, but it hadn't been until this morning.
They say that all of these motions are, and this is on Murphy's filing, filed electronically, knowing I'm not even registered, knowing I have no assistance of counsel, knowing I can't click on it and read it. Now, they can enter...
They're filed electronically, but in addition, they say it's served electronically.
Yes, served electronically. He claimed that he sent mail to me. No mail has come to me. I have a Ring camera. No delivery people have come and dropped anything. I get everything. He's just straight up lying. He never delivers anything to my house or calls me or emails.
But they hand it to you.
They hand it to me.
Which kind of indicates that they know you didn't have it till now. It's not that they're just saying, well, this thing that was the thing that you were served is now ruled upon.
Correct.
Because they know that you'd be like, what are you talking about?
And I'm going to post this amended. I only got a copy of the amended motion in limine, not the first original one.
Now,
So-
to be clear, what a motion in limine is.
To limit what you can say to a jury so that you can't produce and explain all of the defense material that you want to.
Well, in this instance, yeah. Normally, it might be a justified thing, like
There are plenty of
like
justified reasons for it.
But in this case, they're
no.
trying to basically, with motion in limine, I think you said one of them was even that you were not allowed to even submit exculpatory evidence.
I'm not allowed, and I'll post this. I will post this. You guys won't believe it, okay? He said, no, you can't, we can't take a recess so you can read it. No. You can read it here. So I started reading aloud very slowly so I could think of what is it I'm going to do next.
Right. Well, because, I mean, this is a motion. This is something that is a legal crux of a year of threat and over a year of court that he's wanting you to skim.
Yes.
And just not object to. That's part of the purpose. But you're reading it deliberately because it's important.
Yeah, it's telling me what I can get thrown in jail for.
Right.
It says you don't bring this up or this up, otherwise you're against this motion in limine.
It is dire importance that you understand. And normally people have days to reflect and do legal research.
Prepare defense.
Not like minutes before trial.
No, of course not. And here's why they did it. They know what they're doing. Keep in mind, these people have posted plenty of documents before that you could let anybody in public click on that I could read. They know for a fact that they're doing it when I can't click on it and read it. So and again, I'll say it a third time. I'm going to post this later today. You won't believe this motion in limine was the amendment, not the original. So I'm reading an amendment to an original I've never seen. And it says you can't produce the fact that you can't produce exculpatory evidence. By definition, that means it proves my innocence. I can't bring that up. I can't bring up any allegations that, there might be a video. I can't bring up any motions that I've already filed in the record that make statements that they don't want made to the jury about an attack.
No,
I can't bring up the motions to dismiss.
Now
it says that in there too.
Yeah. Now let's go into from their perspective, and this isn't even steel manning because this is bonkers.
Well,
but,
Gary, before you do that, they purposefully prevented me from reading what I would not be able to give them, so I would not have these last 2 weeks to prepare against it. I went in there this morning thinking I could bring all that up, and why would I not think that? I don't find out until that moment that and I'm reading this off with incredulity. I'm reading it off, I can't believe it. I'm laughing. I'm going, you say I can't provide any exculpatory evidence that proves my innocence to this jury?
Now, the grounds upon which they leverage, or they say they're doing this, is because in your discovery, right?
Which I haven't given them.
Yeah, you haven't given them discovery because they haven't yet fulfilled all of their discovery to you. Now, normally it's the accused doesn't have to provide his defense discovery until he's been given everything that's being brought up. They failed in many ways, so they haven't. There's things that they haven't provided you about your discovery and aren't doing. And then they're saying, he didn't provide us discovery, so there's nothing he can now provide at trial. They pushed past both points.
I have the document in my folder. It's July 26th is when Murphy files something to give him discovery. Do you know how many discovery items Murphy has given me since July 26th? He won't stop giving me discovery.
He keeps giving you new stuff, but not giving you things you've requested and have the right to have.
Of course. Everything in violation of the existing Missouri Sunshine Law,
and they're
Brady violations, discovery requests, all three they ignore.
And pushing to trial before that's done to his benefit is my point.
To his benefit, to prevent
And then they say, he hasn't provided discovery. He's cut off from basically defending himself.
Right. Now
by that ground.
I can't bring up any videos, the police body cam footage, my website. They don't want me to bring up the the YouTube channel, YouTube channel. Of course, this was in the motion in limine. You can't mention the YouTube channel to the jury.
And it goes back to the fact that he's played dirty cards here. He failed to do steps that are absolutely crucial in prosecution in a legitimate justice-oriented prosecution. He's failed, and because you can't make a counter move because you're missing his, they're now saying you can't move at all. They're trying to say you can be limited from all defense by the fact that they didn't give you the discovery, the Brady material discoveries, and some information that is crucial. And because of that, they're saying, since we're pushing to trial without doing any pre-trial, we're not completing pre-trial, but importantly, the part we completed, we can leverage to prosecute you, but the defense part that got skipped also
Yeah.
is not available in trial. That's essentially the setup, and essentially what they're executing right now.
What it is you, in so many legalese words, it is this. You cannot mention any facts about the case that go against our narrative, and you can only talk about the limited things that we will allow you to talk about. And then we're going to pretend to the jury and sell it to them that this is actually a legitimate defense, and he just looks stupid. He just lost. He walked out of it. He didn't file his discovery.
Right.
They don't even say. I even asked him this morning, what plea is on the record?
Oh.
Has anybody put in a plea of not guilty against consent or knowledge? I go, Star Chamber. Is this a Star Chamber? I said that today.
Star Chamber,
I said that today.
So, again, we say this, and I imagine, because what I've seen from that judge is he wasn't even looking at you or acknowledging existence of your side of anything.
It was like, he's done this before. Never in my life have I experienced it to this extent. This judge pretended I was a ghost.
Yeah.
Wasn't even speaking.
You're not relevant to your prosecution.
And I was saying completely relevant challenges of my defense to him in response to lies he was saying on the record.
Right.
And I'm not even speaking.
And
now,
he has
Gary,
to.
For a while, he actually let me speak. Okay, so get this. The jury did not come in for a solid 10 minutes. And so the judge is sitting there. We're all sitting there. There's silence. I'm like, well, I'm going to use it. So I start talking. He lets me.
It's like
he gets so sick of it. He's like,
so we've had a mantra going.
Well, but he left after 5 minutes and left the bench, and now nobody's in the room. And so I'm like, okay, well, now the judge isn't here, so I really feel like I can speak without being thrown in jail. So I'm going to say this, this, and this.
Wait,
and
the jury, the potential jurors, it's not a jury yet, but the potential jurors are still in the room?
No, they're not in the room
yet.
Okay. And the judge left, and then when the jury came in, then he came in.
Oh, I see. Okay, so like timeline-wise, there's the portion hearing-wise things where they're trying to clean up some of their dog pile.
Yeah.
And then the jury's there, and they're just trying to shove ahead because they can't really clean anything up. They're having trouble actually addressing major issues that you still have on the table, and they want to push past. But, okay, so, and again, we have this mantra where it's like, rules are for people who are arraigned. So if you're arraigned, they absolutely follow the judge's instructions. If you've been arraigned and got through that, you're arraigned, man. That's your boss. And if you have a full stated cause in nature against you, and the prosecutor provided discovery and Brady and everything, you owe them what you owe them.
Yeah.
But the problem is these things have been skipped.
Yeah.
And it's all, the crux is they don't want to acknowledge that these things have flaws.
They don't want to do it specifically because they know they can't, because I'll beat them in open court. I've done it many times.
As soon as they play the game by proper rules, they lose. And they know it.
Yes. They would have no power whatsoever if they didn't have shut up or I'll throw you in a cage.
So because we've jumped around timeline-wise a little bit, and I've even lost the plot a little bit.
It's hard not to.
So, okay. So let's go from the 9:30-ish kind of time point on, because we're talking about 9:30 to 11:30.
Yeah.
And let's get a timeline.
Right. So 9:30, all the threats are over. They try to bring in this judge, and
wait. No, 9:30 might be too late. So when
9:30 is about the time where
let's go with you show up. Let's go with the startup of you show up and what's going on.
He wants me to sit down. We play this game where it's like, look, I'm only going to do what you say if you threaten me with jail.
Right.
There's no good in this 1 warning, 2 warning, 3 warning steps you're doing. Yeah. Just threaten me with jail, and then I'll do what you say. Because he was making me stand here, he was making me sit there, and he'd never done that before. Last 2, he's like, oh no, you can stand there, that's fine. No, now I have to sit here. You will sit there, or I'll go to jail. Okay.
You gotta say it then.
I'm just making him... This is not voluntary. I'm always under duress. This is coercive threats of violence. This is never-ending bench warrant threats against me, right? So you're going to say here, you're going to say, now you listen. You're going to behave, and you're going to do this, and you're going to... It was just so pathetic. It was so pathetic. I'm just thinking to myself, Johnson, listen to how pathetic you sound right now. You said I've been beating your ass the last 2 hearings in a row, and you are coming over. This is what I'm gonna dictate. You're gonna do this and this and this and this. I'm not scared
I'm in
of you. I'm not
control.
scared of this trial.
I'm
Why
in
would I do-
control of this courtroom.
Yes. Oh, I'm gonna. And then one time he got emotional and started getting angry again. I said, "Look, can we just skip the anger? Could you please do this with professionalism and just not be angry at me? I don't need to. Well, how would I know if you're gonna be angry now? Well, you can tell now." This big frown and raise his voice to me and stuff. It's just so ridiculous. So, I mean, this is what is happening in the big picture is this is the biggest steamroll we've ever seen.
Yeah.
They don't care about covering their tracks. They try to, but they don't care if they don't get covered at all.
Right.
This would never be happening in any kind of case with any kind of attention, any kind of a platform in the news at all to the slightest.
Yeah.
It wouldn't be happening to the relative of a cop or a prosecutor or a judge.
And I'd add to that, I think it's because they've painted themselves into a little bit of a corner. So they started steamrolling and already made a dog pile of it. And then that Elvis Judge shit happened.
Yeah, Thornhill.
And because of that, the lights went up.
Yeah.
And now it's like, how do we clean this up now that the lights are on?
Yeah.
And so they're trying to figure out how to get this to go away. And a good way for it to go away is you plead guilty, you kowtow in some way, you're found guilty and thrown in jail and get to fight from there.
Yep.
Whatever. I don't know, but they don't know how to clean it up given the new circumstances.
They can't clean it up verbally. They can't give me an open mic in an open court and clean it up verbally. They can't.
And they
period.
could.
And they know it. They know that.
Yeah.
So they're resorting because they know, oh, damn it. Well, the normal delay we force of a year to wear them down, that didn't work. He's still here. He didn't miss a hearing and get us into contempt that way.
Right.
He's not doing anything emotional and freaking out and so getting us to ruin it that way.
Every time they make a move over history, not today, every time they make a move, you've turned it around into a bigger pile on the table.
Yeah.
So and so it's not getting cleaner, it's getting dirtier for there. And that's a big problem for them. Yeah. And I think they're just in a point where it's like they just got to flip the table. It's like they just got to make such a mess of it. I think they hope that you, in this, would do something so egregious that they could post that as, well, he attacked the judge or whatever, something bonkers to where they could say he's unreasonable. So, okay, sorry. So that history... So now we're at what, 9/11. So now we're at what, 9/11. So go on from there. Sorry.
So I want to say something about this here. He checked my Garmin device to see if it was a recorder.
Mm-hmm.
Okay. I can't speak as to whether or not this entire thing is recorded.
Mm-hmm.
We just know that they claim to be recording for the quote unquote trial. Now, he was under the belief that he wasn't being recorded during the first 20 minutes, and if that recording or history that they're already making ever found its way, again, into a big platform, he'd be totally screwed. Totally screwed every which way from Sunday.
Yeah, there's a lot of this history where the verbatim things that happened, they don't record. They just say, oh, well, this is what we feel happened. Right. And it's like, no, that's not what happened.
So continue with the timeline. From what I remember, it was just... read this motion in limine.
Okay, hold on. So you go through the Garmin thing, all that, and the stand here, and now they're handing you the amended motion in limine to a motion in limine that you hadn't read the original of.
Correct.
And they're saying, read this.
Correct.
And you start to read it slow.
Yes.
You start to read it deliberately.
Yes.
And what's happening in the meantime?
Prosecutor keeps talking. So I say,
the prosecutor's talking to the judge.
Yes, and I'm listening through.
While you're required to read the motion in limine and object to it.
He's doing both at the same time. And with disbelief, I'm like, I'm trying to read this, and he's talking at the same time. Can I do one at the time, please? And
because they don't want you participating.
Correct. They said, no, I couldn't. He says, too bad.
Too bad. Yeah. It's like you're going to sacrifice one of your feet. We're going to, we shoot one or the other. So...
they're so intimidated by me, they can't allow me to read what they're attacking me with and have time to defend against it.
Year of, and this is, a critical motion.
Critical.
If they tried to do this to a lawyer and said, by the way, here's a motion in limine
Can you imagine?
For the trial we're starting now.
Oh, my God. Can you imagine? They'd be like, excuse me, I need to call the bar right now.
Right.
I need to call the bar right now.
Right. For one, it's like, why did you just now give me this motion?
Yeah.
Now, you've handed in motions that were critical to what's going on about things that happened the day
Motions to
before,
dismiss.
about things that happened the
4.
day before,
Yes.
and they're saying we're not hearing this because you didn't give 4 days notice or
Correct.
whatever.
Oh, no, they didn't say we're not going to hear it.
Oh, they just deny it.
They said what you filed, I've read and I'm ruled against. That is all, and that's it.
Yeah.
When I say that's it, I mean that's it. That's all the words that was allowed to spend on my motion. If I spoke more, I'd be risking getting thrown in jail.
Okay, so.
And read those motions. Read what's on those motions.
Yeah.
They're so powerful. That's why he's not allowing them to be discussed. Because they're so powerful, he cannot contend with them.
Yeah, there's a whole lot of information behind them.
Yeah.
And there's a whole lot of conversations with AI, LLMs, ChatGPT, whatever it be.
Yeah.
And while all those things can be dire wrong, but given enough work and investment, they can be great. So they're talking, and actually, if I'm remembering right, they're granting that motion.
Oh,
yeah. They're basically telling you.
This is the best part. Okay, another notch in my belt.
Okay.
To go along with being held in contempt but not going to jail.
Okay.
That was a new notch in my belt. This other notch in my belt is he had such a rush to grant this motion that I had just been given, this motion
in limine
amendment, right? That he approved point 1 before I started reading point 2, and he approved point 2 when I was only halfway through it. I said, do you mind if I read the rest of this before you grant it? He didn't answer me, and so I just kept on reading from the middle, and so I continued point 2.
So technically he's granting motion points while you're still reading them.
I've never even got a judge to ever grant or deny portions of a motion before. He was doing it point by point.
Here's the thing, and just to reiterate.
Hold on.
Oh, sorry, go ahead.
Point 3, he said he granted that one too, and I hadn't even hardly gotten to it. I think I might have read what sentence 2, and then that was it. I just moved on after this.
Okay, here's the point to this.
This is insulting.
Here's the point to this.
This bullshit. Go ahead.
These motions were communicated to the judge days, weeks, whatever it be ago.
On the 2nd, on the 9th, and on the 11th.
That is ex parte communication.
Yes, 100%.
Because, you can't clean up an ex parte communication by last minute saying, by the way, here's the conversation, essentially the communication that's been underway for weeks between us. It's to them, it's old hat. They are on the inside track of this knowledge. It is ex parte communication.
Yes.
It's just they had to clean it up last minute before trial. They couldn't do it after trial because that's a little too clear. Now, I'm sorry, you still haven't been informed. There is still one more ex parte communication in that the original motion, which is probably granted.
Which? There's so many.
The amended is granted, but the original motion in limine.
Who knows? I wouldn't know what that even says.
Right, because it's...
Don't mention the dog attack. Don't mention your YouTube channel. Don't mention exculpatory evidence that proves your innocence.
Right.
Don't mention anything that could get the jury to be not guilty or have a reasonable doubt.
Right.
God.
Right. That's the secondary. There's all kinds of motions that are, there's all kinds of limiting points that you're bound to that you're still uninformed of.
Yeah.
Because it was an ex parte communication from Murphy to, is it Johnson?
Yeah.
Johnson. So it's just bonkers that this even happens. Imagine, so you're a pro per. You're in your own person at this place. If you had an attorney that they were treating like this, that was so unrelated to the communications about what's going on.
Yeah, get this.
Yeah.
I didn't tell you this.
Okay.
I lied and said I just signed with the public defender. Can I get some assistance of counsel, please? And he ignored that. He did not know that wasn't true. For all he knew, I went downstairs and signed with the public defender right then and there. The second this thing got over and I left voluntarily because of the threats of prison, guess where I went? Right down to the public defender's office. And I told cute, what's her name, Claire. I said, hey, Claire, I'd like to leave a message. And I left a message for Katie, who runs the place, and said, you guys have no obligation. Your office has no obligation. I'm just letting you know that the last email we had, I requested standby counsel of this office.
Yep.
Standby counsel exists as a concept.
Yeah.
I want it from this office to protect me against this lunatic.
This bonkers.
This guy, his buddy was just taken out for corruption.
Right.
Thornhill was taken out for corruption.
Yeah.
He's doing even worse things than Sandcork did.
Yeah.
This is going, look at what it says right there. I pointed this to Claire. Look at and I said it very calmly, not adamant.
Like we're doing now.
Yeah, I said it very polite and very soft, I said, look at this on your wall. It says, hey, we believe men where everybody has the right to assistance of counsel during criminal
Yeah.
prosecutions. I said that's going on right now in your trial on the fourth floor.
Unless the judge really doesn't like it. Yeah.
It's going on right now, the trial of the fourth floor, and somebody doesn't have the assistance of counsel. So, whoa, if Katie cares about that, just to have her get back to me about, hey, can I get standby counsel? And I don't expect anything from this office. Have a good day.
And yeah, mainly because they one of the to reiterate something from the past. One of the requirements that they have is that you sign away your right to challenge jurisdiction or have issues with jurisdiction. And there are two jurisdictional problems that are major, and one of them is that statute removes jurisdiction on this topic from this court.
The absolute defense part.
And not only there's an absolute defense within, but preceding that, they remove jurisdiction from the court on the topic. So there's two things: absolute defense, and they deprive this court of jurisdiction on this topic. So it's like, so you ultimately that could be used to say, well, you waived that statutory benefit, whatever. I'm just saying there's a problem with that, signing that thing. But okay, so now we're at the point of you're reading point 3 while he's granting the motion. Basically, it's a rubber stamp system.
Yeah.
It's a rubber stamp system where you're lucky to even, they consider it a privilege to even tell you a hint of what is being granted.
Yeah.
They're granting things without you ever being informed about it because they just don't really care about cleanup work.
Yeah.
This is already so messy, they don't even know what to make of it. They just need to do things to make it look like they cared about general topics.
I believe after going through this for 16 months, Johnson is following orders. He has been given instructions, most likely from the presiding judge who replaced him for Sandcourt, and they are following an agenda. And they know goddamn good and well they can never let this happen in a jury with an actual bar member on the other side. They know for a fact they can't. Their strategy is to just screw this guy. His channel is tiny. He's not from here. He doesn't have a network of family and friends here. He's going to be steamrolled by you. He's going to do all his whining and crying. It's going to fall on deaf ears. The appeals court is in our back pocket. Everything about this process, from the police to the prosecutors to the judges, 4 judges have been on this case, and one pretending to be one in jail who wasn't one. All of this, the Missouri Sunshine Law violations, the state AG office has a direct department and complaint that does nothing but sunshine, and I've submitted those, and they do nothing. The Commission on Judicial Conduct, and I've filed about these judges then. They respond with nothing. There's no judicial oversight. There's no redress of grievance. There's no equality under the law, and all of this just goes toward that whole effect. And, man, I know we're just at midway, and I'm still trying to go through all this.
But there's points that could come in. But to that, before you move on from that, to that point, that idea of equality. Okay, so there is actually a big thing that keeps coming up as a theme in this: homeowner versus rent.
Yeah, it keeps going.
Homeowner versus renter. It's every like it keeps coming up in weird places where it's like the homeowner, they're a renter and they're a homeowner, and it's like, wait a minute, you seem to be choosing sides based upon whether someone pays rent or pays mortgage. And it's like, oh, do you get extra good treatment because you have property taxes that you can control? It seems to be
all
a theme
over
here.
Facebook. It's stories they've told I haven't dealt with. It's on GoFundMe. It's Facebook, GoFundMe, and on the police reports. Yeah.
And it's funny that there's a lot of people who seem to really care about and know that the system will care about that they're a homeowner and you're not. I'm just saying that that's a point around here. Maybe it's a big point about the politics.
If that wasn't the case, this would have never been happening to me. If I owned that home, they would have said, "Oh, this is a civil matter. If you want to sue him, go ahead."
So I knew that was a side. I hate to do asides. We have so much to cover, but the one aside is when I lived in Ferguson, Missouri, of the infamy of
Mike Brown.
When I lived in Ferguson, now Ferguson has two kind of halves. It has that homeowner.
Yeah.
Let's call it homeowner, upper echelon, whiter community.
Property taxpayer.
And then they have renters in some apartment complexes. And there is that divide of us versus them that was central to that blew up with Ferguson. That was what that explosion was all about. It is renter versus homeowner. That was one of the powder kegs that was related to this. And that's why the cops were messing with people who were renters at that one side. And it was different.
There is a social class. Undeclared social class.
And it's a legal, priestly class. Yeah. Homeowner is a little extra privilege.
Oh, yeah, because homeowners pay property taxes.
And I'm just saying that it seems to, and we're just a few feet away in St. Charles.
Yeah.
We're a 10
We might
minute.
as well be
We're
St.
a
Louis.
10-minute. Well, for Ferguson,
Good
we're
Lord.
10 minutes away from
10
that
minutes,
area.
yeah.
Is my point.
Yeah.
Okay, sorry.
No,
So
it's good detail.
So 3 points. So the third point, you just ruled against you. They're discussing what you're going to be bound to while you're reading it.
Yeah.
They're basically having a discussion about how approved it is while you're reading.
Yeah. And I'm just thinking, okay, make as many errors on the record as you can, appealable errors,
Yep.
note everything they're doing.
Reversible errors.
Errors. Yeah, and just don't try not to miss opportunities, of course, and
Yep.
it's coming at the same time. One time I asked, hey, I just need a few moments to think. He said, no, ask a question. I said, oh, I guess I don't get time to think. Okay, and I did ask a question.
Hold on. So that's a point. Such a small things, but it's huge.
It's huge.
So there is a duty to treat someone who is, they call it representing themselves, but someone who is unrepresented by an attorney, to treat them not worse than an attorney, but with accommodation to the fundamentals. Yeah. We get into that in a moment where the voir dire and so forth, where they're just basically like, hey, you're supposed to know how to phrase these questions. Fortunately, you actually did phrase them right, but they're acting like you didn't anyway.
Yeah.
So it's like, oh, well, presumes facts on an evidence. We'll get that in a minute. But it's like, no, it actually didn't. It was a hypothetical question with a proper structure.
Yeah.
But they're supposed to let you know about the nature of the proceedings so that you can progress.
Right.
Not, oh, well, we're going to pretend you have a bar membership. Mm-hmm. Not just that you're intelligent. Mm-hmm. Pretend that you have a bar membership and treat you restricted in the same way that the bar members are restricted.
Yeah.
It's supposed to be for the preservation of their client, but here it's to bind you into not defending yourself. Yeah. Sorry, that's a rant, but okay.
No, it's 100%. It's in essence what is happening. When you learn these words, look, if they're right, they would just contend with you verbally, shoot you down, and then they would win. And you know what? Right. A jury would vote for that person to be found guilty because they're doing and saying all these things wrong and correct and being run over by a correct judge according to their procedures now. When you come at them in a way where they can't beat you, the only thing left to them is make it last forever with meaningless hearings.
Right.
Oh, wait, that's
meaningless hearings is important.
Hearings, yes,
because they've spent so much time.
So much taxpayer money.
So much time that could have been, with an honest, forthright approach, been resolved in half an hour. Yeah. Now, here's the problem. That honest, forthright half an hour would have canned their whole prosecution. It would have become clear that they can't do it. That's what, all these hours to finagle a system and not be forthright. That's what my point is this isn't like, oh, they waited tons of time, but not, in addition, they dragged you to court many times with tons of time involved and tons of effort by everybody involved to not answer questions. But to basically bully their way past questions that were simple, yes, no questions, that you had the right to know, supposedly. Yeah. All these kinds of things. So we keep reiterating that. So, okay, sorry.
No, it's so critical. It's hard. You can't step on something that's not a massive pile of shit.
It's a massive problem with each step of what they're doing. Every minute they're doing horrifying things. But okay, so the horrifying thing that we just got past is he's telling you can't ask the question that you were just mentioning. I'm sorry. Rewind to what we were just talking about.
Can't ask which question?
Let's back up and get it start right. So after the motion in limine rubber stamped.
Yeah.
And then we move on to what's next.
Yeah, that's what I'm kind of fuzzy on because there was this transition. I'm trying to think to myself right now, was there anything between forcing me to read and deal with these ex parte communication motions between that and waiting on the jury to be called? And I think there is, but I just can't recall it that well.
The enemy thing.
Oh, yeah, I could talk about that. So at one point, I wanted to get formal recognition from the court that this judge is my enemy, acts as my enemy, and everything about him is my enemy. And, of course, he didn't like that at all, threatened me with jail over it. And then I continued with another comment. Every time I open my mouth, I'm risking jail. And I continued with another comment about it to clarify. And in that clarification, I said the word enemy. And he said, oh, that's it. He interrupted me. That's contempt. And I was expecting to go to jail right then. I did not. Found out, oh, he's going to hold me in contempt without holding me in jail. Okay. So that's just what all that was about.
So what's behind that is the more formal word would have been adversary, right? He is actually biased to the point of acting on the prosecution's behalf. He is acting as prosecution.
I burned him with the, is this a court of inquisitorial or adversarial? I got that out clear as a bell on the record 2 or 3 times in a row. I could. Is this an inquisition? You're not letting me talk. You're just dictating to me. Do I get to respond at all here? Is this an inquisitorial court or an adversarial court? I got that one out too.
Yeah. You also got out the Star Court. The Star.
I got out the Star Chamber.
Yeah.
Star Chamber.
Okay. So is this still all of this before
the jury comes in? Yeah. All of this is still before the jury comes in. Let me think. Is there anything else critical I want to bring up? Before the jury came in, it was just, arguing over the seat here, arguing over, no, I'm not going to pretend I'm threatening you with violence. Yes, you need to threaten me with violence before I'm going to do anything. The motions, shoot down all my motions. I'm going to tell you this is
how reject your motions and go point by point on his.
I'm going to tell you this is how it's going to go. This is what you're going to do. You're going to do this, and you're going to do that, and you're going to do this, and you're going to do that. But this man, obviously,
But what does he say? Is there anything he's saying that is surprising in that? It's like it's
just treating you like we're so far beyond this, Johnson.
Yeah.
You actually taking the time to actually tell me what's going to happen. Everyone knows is a complete waste of this court's time. I don't give a fuck about you, Johnson, or your authority. I don't consider you a judge. I consider you my enemy. So was he talking
about the whole prosecution's going to present his? And then you're going to cross, was it that kind of thing?
Look, you were there last hearing, right?
Yeah.
This is what he did. Everything and every which way that I kicked his ass last time, he was saying shit about how I'm not allowed to do that this time. He was protecting himself.
Yeah, okay.
That's all he was doing was just,
this is how this is going to go down. He was basically saying, don't do that again.
This, you're going to sit here and you're going to obey, and you're not going to do this, and you're not going to do this, and you're not going to do that. It was a lot of that. And I'm just sitting here laughing. I can't interrupt. I can't tell him to stop talking because I'll get thrown in jail.
Yeah.
People just don't understand what a court hearing is like when every single time you open your mouth, you're risking prison.
Yeah.
There's just a whole bunch of stuff I would have said. I just can't. So don't. Choose not to. I'm not going to prison over that one.
You have to pick exactly when it's effective enough to risk.
I can only say things that I know.
When it's worth it.
Yeah. That, and I can only say things when I know that he feels he would look really stupid for putting me in jail for that particular line.
And again, it's a workload that you have to be internalizing, where it's like I'm not only fighting the case, which they haven't even informed you of properly, and the motions that they're secret from you and all this stuff, but also this chaos introduced by the judge.
Yeah.
Okay.
So all the documentation is continuing. There's going to be obviously motions. I don't want to talk about that here.
Okay. So jury is filing in at this point.
Jury's filing in. Yeah.
So after he gives you the rundown of what's not going to happen, how you're going to behave yourself.
Right. Then we're waiting, several minutes for the jury to come in. 5 minutes go by. I start talking because nobody else is. I start saying things.
Wait. So while it's still empty, the judge is out.
The judge is in the room. Judge is in the room. Okay. And I start talking because nobody else is. So I start just saying random things. God, what would?
Well, not random things. Things are germane and on the topic.
They're like, I think I said something to maybe looking at the bailiff. I don't even know how anybody ever works for these people. Just random weird thing like that. It's just so. Well, I won't comment on what I thought their opinions were, but I'm just gonna say this. I could see from the faces of the admin, they are not even looking at me. Mm. They don't even want to have to meet my eyes. They're well aware. If anything, they're looking like they don't want to be there. Yeah, they're looking like, oh my God, they're just tolerating this.
Yeah, this is.
They look like
this is not what court is supposed to be to them. No, this is not. Yeah. And I think that there's some part of them, their ethical conscience maybe, that knows that this is Star Chamber shit. This is they're
just steamrolling. They can do whatever they want. Steamrolling. Yeah.
Kangaroo court, steamroll, Star Chamber. Call it what you will, but
yeah.
Okay, so
I did that for a while, and then the judge decided to leave. It was just too long of a wait, I guess. And so he's like, so he was gone and then 5 minutes more. They were ready, and so then the jury came in, and then the judge came in, and then in essence, it was a bunch of jury instructions. Of course, they didn't let me give my instructions.
Yeah, the jury instructions that the judge told the prosecutor to write to his will.
And have a deadline. He said, during a hearing, prosecutor and judge are going to have instructions by this date. I said, I'm going to have instructions by that date too. He said, cool, fine. I then filed them. Uh-huh. He said, they are due by this date from everybody. Yep. I filed and agreed with them. And he won't let me bring up the jury instructions. I can't give the jury instructions.
No. It's
the jury instructions Well, I have them here, and I'm going to put them on the YouTube channel too tonight.
Okay.
They bring up every issue with just their instructions for the jury to give to the judge, instructions for the jury to give to the prosecutor. They are more powerful than the judge and the prosecutor, and I'm trying to arm the jury with knowing this information. They don't have to believe the opinions. I got this out too several times. Upon what factual evidence do you rely to form your conclusions, or are they merely just opinions? Like, he's claiming, and the language is such that these instructions make it appear to an easily manipulated jury member that they actually have to do it. And they use all the buzzwords. And while they're using the buzzwords, you know, like duty and honor, and I'm just shaking my head, like rolling my eyes, going, "Oh my God!" During all the instructions. Of course, I can't say mine. If I could say mine, if I could say mine, if I could say all of my jury instructions to the jury, I promise you, by the time they woke up tomorrow morning, they'd be like, pissed at the court for even calling them in the first place. I really got to hear a lot of jurors just show up and be like, I don't want to be here. I got this going on. I got this going on. My dad's dying of cancer. This person's in the hospital. I'm on call. I got to have this trucking load in California in 2 days. This, that, oh, sorry. But the laws of Missouri are going to require that you be here. Sorry. And then one guy went up there and was speaking so softly, I couldn't even hear a goddamn thing he said, but he got approved. I don't even know what it was, but the judge says, oh, you're excused. Goodbye.
Oh, okay.
Just side details, but all this was going on here.
So the point therein is the judge asked the prosecutor to basically formulate the jury instructions again to his own liking. There's no equality. There's no adversarial nature to that, of course.
It was interesting. He had to go over the parts he doesn't want to go over, like jury instructions. You do realize that the state has to prove every allegation of the case. Things like this that they don't want to say. Every element of the case. Things like this they don't want to say.
But they don't want to say that one of the elements is that the dog was not. Right. They would have to make an element be that the dog was not attacking you.
And the nature of the questioning, like some of his questions are just rhetorical. They're ones that nobody's going to raise their hand and volunteer and say this. This is so stupid. It's like it's an obvious question for everybody to go, yeah, that's me. Duh, that's everybody. That's why, you know what I mean? And another thing, why not just ask him like questions on paper? When you ask people questions in front of each other with public pressure,
put up your hand if you've ever
isolate yourself.
That
pressure. They don't answer honestly, or they're not going to answer at all. There would be questions like, who here has had a problem with running into the Justice Department, whether it be a cop or a lawyer? 2 people raised their hand, and everybody knows. And one of the 2 people said, well, everybody knows, everybody's had a traffic ticket. He spoke for the whole group, like, we all know it, we all run it, you know what I mean? Anyway, I'm spending too much time on details, but the point is just that it was directed by them, and I'm not allowed to say anything because I can't.
No. And
they asked for my instructions and wouldn't let me give it.
Well, they begrudgingly let you give your instructions, and then
I did not give my instructions.
No. I mean, they shit-canned your instructions.
Yeah, they didn't give it to me. They didn't let me deliver it to the jury.
So wait a minute. So the prosecutor was the one giving the instructions?
Judge gave instructions to the jury.
Okay, I'm sorry, because that would be additional.
I misspoke because the prosecutor said he was going to give instructions.
Essentially, the judge is acting as prosecutor in this.
The prosecutor has written instructions to the jury. I just didn't know if I heard them or not. But I heard a lot of judicial instructions, and they're not going to let me say mine. They'll accept my instructions as legitimate, but of course they won't let me say them in front of the jury, because the jury is going to be pissed at the government. Why are you charging this man? He shouldn't have ever even been charged according to the damn laws on the fucking books.
Okay,
and
we got to get to that point.
Why did you call me in the first place?
We got to get to those points.
I keep jumping ahead.
You're jumping ahead. Okay, so jury instructions.
Yep.
By the judge.
Yep.
And then we move on to
Murphy's got about, I don't know, half hour, 45 minutes to go through his voir dire.
And he's and he's asking the normal shit voir dire.
Normal stuff.
Where it's like, like you mentioned, where who here's been in court and who has a cop as a brother and whatever. That's
silly questions. Just like, come on, really? Like, you gotta be more specific.
They basically, in order to curtail your ability to avoid deer, they come up with a bunch of garbage.
And 100%, he's looking for people who automatically have been fucked over by the justice system, so he can eliminate
that's
them
what he's looking for. He's looking for people who are jaded.
Every time he got a question like that, he's like, what's your number again? And I'm like, for sure he's writing down that number. You're not going to let that person be on the jury. And I told them at the end, and I don't mean to fast forward again, but I told them, look, I don't take this personally. I don't blame if all of you vote guilty because of the lies they're going to say.
The rest of that story is actually more interesting than that summary.
That was right at the exit.
Right, but okay, so he voir dires and he's presumably making his list
Yeah.
of people.
So he goes through, yeah, whatever.
All right. And then now on to your voir dire questions.
Well, I should say, while he's doing this,
Mhm.
I'm taking a risk by saying this, but I'm going to say it. So these morons put Murphy in between the judge and me. Okay? These bailiffs aren't reporting on me. I'm giving indications of what is true and what is not that Murphy is saying.
Yes, yes.
I'm giving
your body
indications-
language
yes.
and your facial
I'm
expressions.
giving universal symbols and signals like
Yeah.
sign language of being gagged,
Yeah.
of having a zipper
But
across my
again-
mouth that I can't speak.
But again, being refrained from. He did. Again, he threatened you on the speech point.
Yep.
He didn't say if you move your face
Right.
and if you move your hands in any way that's communicative, that's also restricted. So again, I don't think that he would have to say, "Listen, I need you to act unnaturally," which again is a problem because to say act suspicious like
Yeah.
isn't a valid
Act unnatural.
right. The fact that you're gagged is already unnatural.
Oh, yeah.
And the fact that you're, because of being gagged, acting like someone who's gagged would be a notch further. So I'm like, you know what? That's a full, natural, normal communication that I think you have every right to do.
Every human being is wired to operate within a tribe. And when there's a conflict between two people and they contend and they know this, no, my version is true, no more. Other tribes people, all have wiring for this. We can detect bullshit in ways we aren't fully educated about from birth. Like, we have instincts for this, instincts for detecting truth and everything. And that's natural, and it fits right in our DNA. If two people are arguing and a third person is listening, a third person can come up with their own opinions and will as to who's telling the truth and who's not. Maybe 20% on the words actually said, and maybe 80% on the body language and the tone in which it's said.
Exactly.
And so the further away you move from that artificially and construct this
Right.
judicial system by forcing people to act like a schizophrenic.
Yep.
And like, oh, you got to ask the question and give the answer.
Yeah.
Oh, you can't ask this kind of question, but this kind of question over here, you can. You just
Yep.
can't introduce narratives against our narrative in your question.
Exactly
You were
that.
making this whole system like a pretend jury trial when it is actually anything but a legitimate jury trial.
And
Go
the
ahead.
thing that creates that would be fair is a fair arraignment system where it's
Yeah.
like, but if you get rid of a fair arraignment, you get a unfair jury, unfair trial system.
I wish I would have said that in front of the jury. I wish I would have said, do I have a right to a speedy trial? Shoot, do I have a right to a speedy arraignment? And because I've never been arraigned.
Right.
What record? I wish I would have said that. What please on the record? I didn't plead not guilty.
And you didn't refuse, and you didn't refuse to plea.
And I never refused to plead. You
You-
guys stopped trying
and
to
you
get
didn't-
me to plead.
And you didn't try to conditionally plea where you say, oh, if you pay me this much money, I'll plea. It is listen, if you inform me of the cause of nature
Yeah.
on this point that I can
Yes,
define and
yes.
clarify, if you clarify that, I will plead guilty. Why? Because they can't clarify that.
They can't clarify that. And this is what I want somebody to get. If they only listen to the one thing in this whole live stream, it's this. The entire crux of the issue that I bring to the table, and this is outside of the actual facts of the case of the dog biting me, is this. This clarification of has the prosecutor provided any factual evidence regarding the element of jurisdiction? If I'm wrong and they're right, I'm saying I'm open to being wrong and you being right. I just want this yes or no clarification to be informed of the cause of the charges, like it says in your amendments that protect me. They will not say yes or no.
Nope.
If they say yes or no, I plead guilty. I'll sign it and leave. I tell them this now.
Yeah,
I
of
tell
course.
them this if they have to do the informed part
Right,
too.
right.
Informed and the voluntary is one thing. Informed is
They've
another.
just confessed to either a crime
Right.
or
Right.
or that they don't have a case.
For them to fight me, every fight, I just got to say this, every fight that Johnson puts up, that Murphy puts up, that other people put up, every bit of fight they put is all can be solved and made go away if they'll just answer, has the prosecutor provided any factual evidence regarding the element of jurisdiction of the court? Yeah, and they can't because it's a catch-22.
It is.
Because the entire system is built on a hustle,
Right.
and they don't want other people to discover this because then they'll do it too. In this sense of fairness, why does this person get away with all these parking tickets, speeding tickets, yellow light tickets that I've gotten away with, documented on the Missouri record?
Yeah.
Never mind other states, and I have to put up with them. They're terrified of this one clarification coming across. I said it too. Military courts and church courts do it too. I said that today too. So I just want anybody to know. I'm not fighting about this, that, and the other. They're saying I'm fighting about. I'm fighting about this clarification to be informed of the cause.
And it opens up a reformation of the court systems itself. That question, the fact that you have the right to that answer, opens up the reformation. It's that they've got to squelch the question, because otherwise the whole system gets reformed to something better. But okay, so sorry.
It's this about jury. I'll go to jail for you or whatever. Your lives collectively is gonna get worse if a jury hears this case and goes, fuck everything about that guy, guilty, guilty. And likewise if they went not guilty, or likewise if they even went innocent. My God.
The fact, the events of this is going to cause problems for somebody. Like if this, well, we'll go to that later. So we're still at the point where you're about to ask question one of your voir dire questions. Yeah. Okay, so at some point he's done with his voir dire questions. Yeah. Has written down his people that he wants to eliminate. Maybe hasn't even eliminated them yet. There were some people that had said that in that whole thing they have other things they should be doing, right? Was that in his voir dire where it's like, I'm really kind of busy, I have a mom that needs whatever, or whatever, Dad?
Yeah,
is that during his voir dire?
No, I believe it was before.
Okay, so some people got approved for excuse.
One person got approved to leave, and 5 got denied.
5 got denied.
I took all the names. Yeah, I took all the names of those jurors, and this was part of the scene when I left. Is I want all.
We'll get to that. Okay. I just wanted to prep that.
I tried to free them all. The judge wouldn't free him. The state of Missouri, you have to be here. Sorry, that's too bad. You have to make accommodations to be able to take time off to fulfill your duty.
Tough on you. Fulfill your duty.
It doesn't matter if you're getting paid $500 less and you're losing that in wages.
Right. Or that you're trying to shuttle your mom to
a trucker going back and forth to California is probably going to pay him between $1,750 and $2,500.
Yeah, because you miss a load.
Yeah,
going out there. That's
a 4-day minimum, 5-day trip.
Because that is a full week round trip, and you can't start it on a different day, or quite align it. It's not that you just pick another day.
Too bad. I'm sorry. You're just gonna have to. And I was like, I'm trying to let them all go. 5, 6, 8, 24. All of you, I want you to go. I don't care.
So you said that later.
Yeah, I said it later.
But you're at question one. So let's
rewind back to. So it's my moment. I'm taking my time. I'm not doing anything 100 miles an hour. I make it kind of dramatic. I get up, I asked my first question. My questions were awesome. They were all written by ChatGPT. They were relevant to the issues, and they were questions written such that they introduced the fact that, how dare they introduce the fact that this
on a hypothetical, though.
Yes.
If hypothetically,
if evidence shows that the dog attacked me in an imminent attack.
And I shot.
Yes. Has a crime been committed?
Well, I thought you said it had something to do with. If you hate,
it's in the folder right there.
Yeah, if you hate, well, it's essentially if you shows, and you hate guns or something like that.
Yeah, that's right. That's what it was. That's how it ended.
Yeah.
If evidence shows that the dog intentionally attacked me, I don't remember how it ends.
Would you be able to find me not guilty? Would you be able to find me innocent? Even if you don't like guns.
Because the next question had to do with guns.
Yeah. Even if you don't like guns.
Yeah. I'll post
that one.
I'll post this tonight.
Because it was a hypothetical based upon a potential.
If the evidence shows.
Yeah, if the evidence shows. The opposition said, presumes facts not in evidence, even though.
Yeah, you can't ask that question.
It's a hypothetical.
It testifies to evidence.
Because it indicates. Because he didn't like the fact that you alluded to with a part of the case.
Yes.
That he wanted to exclude from the whole ordeal.
They don't want anything about the dog attacking me.
He did not want the question of, wait a minute, was the dog attacking? That's an element, by the way, of the crime.
Correct.
An element of this abuse is that the animal is not in the process of attacking you.
Correct.
Because you can't abuse an animal that's attacking you.
Correct.
You can. It's not abuse to
it's not abuse.
Fight it.
It's not an injury to shoot a pedophile attacking your child.
Right.
It's not an injury.
It's not an injury at all. It's not abuse of a dog
self-defense.
To defend yourself against it. Yeah, that's the point. It's an element.
Yes.
It's an element.
So
you're talking about an element.
Yeah.
Not a fact of the case. It's an element.
That crucial.
And
that
he
necessary.
Objected.
And
the way he
they
objected.
don't want, again, every step Johnson takes is, I don't want the word attacked in
So-
this case at all. You can't,
so-
you're not allowed to say that the dog attacked you. You're allowed
You
to
weren't
say
even
that
saying.
it walked across the street into your front yard and you shot it.
Furthermore, you can't even say that attack is an element of what's going on.
No, and then when it comes my turn to provide the evidence, he's going to say, you didn't give us discovery.
Yep.
Therefore, the prosecutor didn't have a chance to look at it. Therefore,
Yep.
anything you say about
You're
the dog
barred-
attacking, about the YouTube
You're
channel,
barred from anything.
about any of that.
You're basically hogtied
Yeah.
from using anything.
I can't defend myself
because
whatsoever
of
because discovery is not
discovery is not in. Because you didn't get your discovery
and I kept
either.
getting discovery until the last minute.
You got
and
parts
then
of
he
your
won't
discovery,
let me
but you
read
never
discovery.
got discovery. You
won't
never
let
got
me-
the end of discovery.
I
You
can't
have
even read motions.
so you have evidence that you know exists that he has that he's refusing to give you
Yes.
to this day, today.
Yes.
So my point is that
Ongoing.
you can't owe him discovery when he has not completed giving you discovery.
Correct.
He's trying to close the discovery box.
People don't
and
realize.
he has because the judge rubber stamps it.
People don't know. This is how the system is. If I'm paying a lawyer $250 an hour, and he's paid to design my defense, I need the offense to say, okay, we're done giving you everything we've got. Prepare
Yeah.
your defense against this.
Yes.
The legal system allows for that. This is normal procedure for everyone.
Right.
And for them to not do that and be like, no, we're going to keep giving it to you. Now I got to keep adjusting my defense. Now they say, you can't even read what we give you. Therefore, you can't defend against it because you're so goddamn effective at defending against it, Joe. You got a Toyota. It can take it. You're so effective against it, defending against it, Joe, that you beat us every time. Therefore,
Right.
we can't allow you to.
So
speak
we
with
had
us until you shut up, Joe.
tilt this
Yeah.
table a little bit.
And I've got motions in saying, can I appear every time via webcast, please? Because the judge is always threatening me with jail, and I'll not be able to speak and finish a sentence without being threatened with jail.
So, okay. So question 1, objected to, judge, of course,